Yeah, well, the reason that I said that about what Robert Buckland said in the House of Commons yesterday, I mean, I'll just read you his tweet if I can. So, I mean, he said that, rather, I'll read you what he said in the Commons. A lot has been said, he said, about necessity as if it requires imminent peril. Well, here's what the International Law Commission says it requires. It requires that the state is safeguarding an essential interest against a grave and imminent peril. So we've got the former Lord Chancellor in the House of Commons saying that it doesn't require the exact thing that the International Law Commission says it does require.
With the exact same words. I mean, that's the end. That's why I'm afraid I guffawed, because the phrase "bang to rights" almost doesn't do justice to this, does it?
No, I mean, I just don't know how he could have said that. Really, perhaps there's some more subtle point that he's making that just has evaded me. But it seems to me that he's just making a completely incorrect claim about what the law is, and this is not a controversial point. I mean, it's there sort of on the page, as it were, in the International Law Commission's articles on the state responsibility.
And he goes all in on it as well. I mean, necessity in this context doesn't require that degree of imminence, except, as you pointed out, it does. What it requires is a degree of real threat and a growing evidence of a real threat to those essential interests. And he goes on to say, I would argue that there is that growing evidence. I suppose we'd have to wait for him to explain what he's talking about there. Could you give us a precedent? Could you give us an example of when the imminent peril or the necessity argument has been deployed in the breaching of treaty obligations in the past?
So I think the key thing is that it's very, very difficult to see how it can apply when, well, for two reasons, really, both looking at the text and thinking about how it's been applied before. I mean, the first thing to say is that in order to plead necessity, this is kind of obvious, but it's got to be necessary. And that means that there haven't got to be other less sort of drastic things that you could have tried, but which you haven't tried.
Like negotiations.
Well, yes. I mean, the very obvious thing that the UK government hasn't tried is Article 16. So Article 16 of the Northern Ireland Protocol says that there are circumstances, I mean, they're pretty limited circumstances, but there are circumstances where the UK can take unilateral action. It's called safeguard measures. And there are various restrictions around that. But basically, if the UK has reasonable grounds to say that the protocol is causing serious problems, there is a mechanism built into the protocol to allow them to take steps to resolve that. Now, it's very hard to see if they haven't bothered to do that, and it seems that then they're saying they're not going to bother to do it, it's very hard to see how it can then be necessary to sort of go for the nuclear option of just legislating to try to override the protocol. And the other problem is that you haven't got to have contributed to the situation that you're now complaining about if you want to invoke the doctrine of necessity. And of course, the UK agreed to the protocol less than 3 years ago, and it's now complaining about things that the government foresaw in its own impact assessment.
I'm no lawyer, but that sounds to me as if, I'm just wondering, in your experience and with your knowledge, you've ever seen quite such an egregious attempt to evade legal reality? Because I mean, I was aware of one or two of the points that you've just made, but when you take them in their entirety, it's as if they've I choose my words very carefully because this is very important territory, but it's as if they're wrong in every imaginable way.
Yes, I think I find it really difficult to understand how somebody who understands the law could really take this kind of view. So, I mean, the government When it published the Northern Ireland Protocol Bill, it published a legal opinion alongside it, which I guess comes from the Attorney General, and it says some comparable things. And again, I don't really understand how they can say what they say.
Well, not least because the actual words imminent peril, as you pointed out at the very top of this, are contained within the criteria for deciding. When you can, just to take you back, if I may, to Article 16, who decides on those reasonable grounds? Is it an autonomous, is it a unilateral decision by the UK government, or is there an overarching scrutiny of whether or not the reasonable grounds for triggering it are in place?
Well, I mean, so the UK would have to be in a position to show that it had a reasonable basis for thinking it needed to take those sorts of measures. If there was a disagreement about that, then there are mechanisms in the protocol itself to resolve that. And in fact, you can't invoke Article 16 until you first entered into consultation with the EU through a special process that's laid down in the protocol. So I think ultimately the reason that they don't want to go down the Article 16 route is both because they can't really know what the outcome of that consultation would be, but I think also they want to drive such a coach and horses through the protocol that actually Article 16 is too limited to allow them to do the kinds of things they want to do. So they've sort of gone for the more drastic option of just saying it's necessary, in our view, to basically just override the thing.
So, I mean, for the avoidance of doubt, this is an attempt to legitimise the absolute abandonment of the treaty obligations that they signed up to just under 3 years ago.
Yes, absolutely. So the withdrawal agreement, which the protocol is part of, is absolutely crystal clear. It says that we have a binding treaty obligation to give effect in our domestic law to relevant parts of the Northern Ireland Protocol. And basically what the bill does is it says, we're going to define lots of bits of the protocol as excluded, and then we're going to say domestic law can now ignore those bits of the protocol that we've excluded. And the basic problem is, you can't legislate through national legislation. You can't legislate your way out of binding treaty commitments. Otherwise, the whole edifice of international law would just collapse.
Can I tempt you then into the realms of speculation? What do you think is going on here? Because there are two options as far as I can see. They either didn't understand what they were signing, or they didn't think that the other signatories would hold them to what they agreed to. Is there a third option? And if not, which one do you think is in play?
I don't think there is a third option. I'm not sure which of those two it is. I think all I would say is this fits, I think, a bigger and more worrying picture where the government is showing itself to be very resistant to things that constrain it, whether that's EU law, whether it's the European Convention on Human Rights, whether it's ministerial standards, whether it's our domestic courts. I think it does form part of that bigger picture.
But whether it's treaties they signed themselves.
Yeah, indeed. Yeah.
Good grief. And finally, Mark, this, I suppose, is a silly question, but you're not in any doubt, I don't think, about the legality of this. What does it do to us on the world stage? What sort of message? Theresa May alluded yesterday to a sort of diminishment of our standing. How does that work in real terms?
Well, I think it must, and I think in terms of our standing to encourage other countries to abide by international law, whether that's in terms of human rights or other things, it clearly impacts on that. I think it also calls into question whether we're a reliable partner in things like trade negotiations, because we're showing through our actions that actually we think that when it's not convenient to us, it's somehow okay to breach our obligations, and that's just not how you would expect a country like the UK to operate.
I don't know that this is a compliment, Professor Elliott, but this is one of the most remarkable interviews I think I've ever conducted, but simply because of the absolute absence of any mitigating factors at all. Your clarity on the egregiousness of what this